Welcome back to online classes. Dear students, today I am going to discuss with Indian Penal Code. Okay, under section 375. We already discussed earlier classes, but this class explanation. Okay, here the only thing to be ascertained is whether the section 375 explanation, okay, not definition, a detailed explanation. The only thing to be ascertained is whether the private parts of the accused did enter into the person of the woman. It is not necessary to enter into any nice discussion as to how far they entered. Even a slight penetration in the vulva is sufficient to complete the offense. Rupture of the hymen is not necessary. It has been said that in order to constitute the offense of rape, it is not necessary that should be complete penetration of the penis with emission of semen and rupture of hymen. Partial penetration into the labia majora of the vulva or pudendum or even an attempt at penetration is sufficient. In one of the case or the point, it was urged on the basis of medical evidence that having regard to that girl age and the fact that her vagina admitted one finger with difficulty, it was not possible to believe that there was penetration. Okay, here and he rejected this statement, and also the argument overlooks the fact that in the absence of penetration there would not be absence of hymen with the edges torn and profuse bleeding from the vagina standing the salvar. Okay, merely because the doctor found that the vagina admitted one finger with difficulty, it cannot be inferred that there was no penetration, as the muscles must have contracted by them. The appellant, a robust man, must have penetrated the vagina, otherwise there would not have been so much of bleeding. The court further added that mere absence of spermatozoa, that is sperm, cannot cast a doubt on the correctness of the prostitution cases. Okay, how the sperm detection test? The absence of such test report, the case of the prosecution cannot be doubted about rape, particularly in the light of categorical findings of the doctor that her hymen was found to have been ruptured. Exception category on the section. The age limit was raised to 15 years by an amendment of the Act in 1949. There may be cases in which the check of the law may be necessary to restrain men from taking advantage of their marital rights prematurely. Instance of abuse by the husband in such cases will fall under this class. A man cannot be guilty of rape on his own wife when she is over the age of 15 years on account of the matrimonial consent she has given, which she cannot retract, but he has no right to enjoy her person without regard to the question of safety to her. Okay, so and another part of the heading in the same section, attempt. What is the meaning of attempt in this section? Intention, attempt, something, whatever it may be. So these are all included in the section. What is that attempt? Here, where the accused degraded the prosecutrix from a canal to the threshing ground, disrobed her and made her to lie down and attempted to rape her. It was held that it was not a mere preparation but an attempt to commit rape. It has been held that intention or expression or even an indecent assault upon a woman does not amount to attempt to rape unless the determination of the accused to gratify his passion at all events and in spite of resistance is established. Where the accused attempted to commit rape on the prosecutrix when she was alone in her house, her cry attracted some persons and he ran away. His conviction under section 376 and read with section 511 of Indian Penal Code was held to be proper. Okay, I'll give you an example. The victim was a minor girl. The accused rubbed his male organ on her parts. She revealed that some white color material leaked out his organ and fell on her private parts. Her mother's version and medical evidence corroborated the girl's version. The court said that it was an attempt to rape and not simply outraging modesty. The accused was held liable to be convicted under section 376 of IPC and read with section 511 of IPC. So the trial court convicted for rape, okay, but the High Court converted the conviction into an attempt to rape. Now it's clear. The statement of the victim in the examination in chief, which was not controverted, was that accused forcibly undressed and thereafter felt very sorry and apologized. It was held that the conviction by the High Court for attempt to rape was justified. An attempt of this kind is a serious offence, as it is an assault on the most valuable possession of a woman, namely her character, reputation, dignity and honor. Okay students, and also the same section also explanation of this ingredient. Indecent assault is not attempt to commit rape. What is that? Indecent assault upon a woman does not amount to an attempt to commit rape unless the court is satisfied that there was a determination in the accused to gratify his passion at all events and in spite of all resistance. Okay students, and also we'll discuss medical examination of accused and victim. Medical examination of accused and victim. This is how the medical examination of accused and victim doing procedure and all in this section. Okay, in case of rape or attempted rape, medical examination of the victim and the accused soon after the incident often yields a wealth of corroborative evidence. Such an opportunity should not therefore be lost any account. Though the prosecutrix can be examined only with her consent, the accused can be subjected to such an examination by virtue of section 53 of Criminal Procedure Code. It is also to be remembered that the accused can demand such an examination under section 54 of Criminal Procedure Code, especially when he feels that such an examination will disprove the charge brought against him. Thus, presence of smegma on corona glandis, that is glans penis, okay, of the accused soon after the incident is proof against complete penetration, since it is rubbed off during intercourse. But to be of any value, examination of smegma must be done within 24 hours. Similarly, presence or absence of injuries on the prosecutrix or accused may confirm or negative a charge of rape or attempt to commit rape, where a married woman, here in this, based on this the example, where a married woman of 30 years having 2 children was overpowered by a young man of 22 years and subjected to rape. His explanation that he could not have succeeded in that single-handed with a senior lady was rejected. The injuries on the private parts of the lady, which can arise only on forced sex, confirming the story. Where medical examination revealed semen stains on the vaginal swabs and salvar of the victim, the court said that at best it is an evidence of commission of sexual intercourse, but not necessarily of rape. Okay students, now it's clear, I think so. This section 375 of IPC, these are all explanation also included. So other explanation also available. We'll discuss with another class. Okay, see you again. Bye. Keep with your legal mind. Okay, bye, see you.